Hello, my name is Dina Miller. I'm a career law clerk with a magistrate judge in the Eastern District of New York and the National Chair of Community Service and Outreach for the Federal Bar Association. I'd like to welcome all of you to day 2 of Bench in Your Backyard, the Criminal Justice System. To help you understand the federal criminal justice system, I've invited today a number of representatives to join me from several federal agencies to describe to you their role in the criminal justice process and also to talk a little bit about typical steps taken in the investigation and the prosecution of a crime. So let me begin by first introducing our very distinguished panel. I have with us today Stephen Shaliro. Mr. Shaliro is an agent with the Federal Bureau of Investigation for the Eastern District of New York. Nicole Beckman. Nicole is an assistant U.S. attorney and the chief of the criminal division for the U.S. Attorney's Office in the Long Island office. We are also joined today by Randy Chavis. Ms. Chavis is an assistant defender with the Federal Defenders of New York. Joining us also is Donna Mackey. Ms. Mackey is an officer with Pretrial Services. And finally, we also have joining us Joan Marie Langone. Ms. Langone is a supervising U.S. probation officer. Thanks so much to all of you for joining us, and I welcome you to answer any of the questions we have, and I'm sure I can speak on behalf of all of our students, and thank you again. What I'd like to do is begin by talking a little bit about the investigative process. So I'm going to start focusing my questions to Mr. Shaliro. And again, welcome, Mr. Shaliro.
Thank you for having me, Ms. Miller.
So, Mr. Shaliro, let me first begin by asking you, how does the FBI typically determine when to undertake an investigation?
Well, the first thing we usually look at is whether the alleged conduct fits within the federal jurisdiction. There are many crimes that are not federal crimes and are more appropriately investigated at the state or local level. Next, we need to determine how that specific case fits into the broader national priorities of the FBI. Sort of what's the big picture of this particular investigation, and does it fit within the overarching goals of criminal justice that the Federal Bureau of Investigation identified as a priority. And then a little bit of it comes down to the individual passions and expertise of the agent. One of the nice things about being an FBI agent is that you are given a fair amount of latitude to decide what investigations you feel are appropriate and important for these skill sets that you bring to the table.
Right. So let me ask you a question. Once a crime is brought to either your attention or the attention of the Bureau, what tasks do agents typically undertake?
Great question, and it really depends on the kind of investigation. But just to name a few, we'll interview witnesses, and that's probably one of the most important skills of any investigator. We'll analyze records if appropriate. We'll conduct search warrants, either electronic search warrants or physical search warrants of locations. We'll do countless hours of surveillance if necessary, and we may even go as far as a Title III wiretap, where we'll apply to the court to take the step of listening in on an individual's telephone calls or emails or other live means of communication, if deemed appropriate.
So, Mr. Shaliro, let me ask you a question. You mentioned in the beginning that there are all kinds of crimes and you have to figure out basically what's under your jurisdiction. I think it would probably be helpful for our students to hear a little bit just about the type of crimes the FBI typically does investigate.
Okay. Yeah, we investigate a wide variety of crimes, and within each category, there's subsets of it. But generally speaking, we focus our attention on counterterrorism, on crimes involving espionage. Those are what we would call our national security focal points. We investigate white-collar crime, organized crime, and what's traditionally known as the mafia. And then we investigate violent crime, is kind of a broad avenue in and of itself.
Sure. Now, I definitely want to talk a little bit more about the investigative process, but before I move on, let me ask you a question that I know is asked in almost every school visit we have to the courthouse of our FBI agents. Can you talk a little bit about how one becomes an FBI agent and what was involved in your training?
Sure, I'd be happy to. Believe it or not, the process starts with an online application similar to a job. From there, though, it moves to a much more thorough process that can take upwards of a year, which include written exams, a panel interview, physical fitness tests and qualifications, and then a thorough background investigation where the individual is looked at to determine whether they fit the qualifications to be an FBI agent. From there, if selected to go down to training, you spend 5 months in Quantico, Virginia. During those 5 months, you'll spend about half your time in the classroom learning about the investigative process. Outside the classroom, you will learn how to become proficient on your firearm. You'll learn defensive tactics. You'll engage in a rigorous period of physical fitness training. And then arrest-based procedures, which may be new to a lot of people who have prior law enforcement experience.
Right. Well, thank you so much for sharing that with our students. So let me take you back just for one more minute to the investigative process. Now, you've described the steps you typically take to gather information and some of the techniques that the FBI uses. Once you've gathered together some of this information, what is the next step that the FBI agent typically takes?
So once you've done your preliminary work, if either the complaint or however it came to your attention proves credible, that you now think you have a violation of the United States Code, that would be the appropriate time to contact the United States Attorney's Office. And in conjunction with the U.S. Attorney's Office, now you would sort of develop a roadmap to prosecution.
Great. Well, thank you so much for answering those questions, Mr. Scigliero. And it certainly sounds to me like this would be a great time then for me to switch my questioning to Ms. Beckman. Good morning, Ms. Beckman. Thanks for joining us. Let me start by asking you a very general question. Can you just explain to our students that are participating, what do you do as a U.S. Attorney's Office, and what is the typical role of the U.S. Attorney's Office in the investigative process?
So the United States Attorney's Office is the prosecuting body for the criminal case. So in other words, we are the lawyers that prosecute the cases that federal agencies like the Federal Bureau of Investigation bring to an office. We have a myriad of roles. In the investigative phase, we will frequently work as a partner with the law enforcement agency in actually developing the case, discussing with them appropriate ways to secure the evidence that may be via a wiretap, using things like pen registers, getting them cell site orders. If they want to search an individual suspect's home, maybe assisting them in obtaining search warrants. And we're essentially the attorney that's getting them the legal process they need to utilize some of those investigative tools. Once the case is moved out of the investigative stage and into the prosecution phase, we're going to essentially be the lawyer that's handling that prosecution. If the case, in fact, goes to trial, we will be the one advocating on behalf of the United States, presenting that evidence to a jury, and ultimately asking a jury to convict the individual that's on trial in that particular case.
All right. So, Ms. Beckman, let me ask you a question. Mr. Scigliero and I were talking a minute ago a little bit about the federal and the state system. And I think that that's an issue that not everyone who comes to our programs typically is aware of. Can you just very briefly address some of the differences between the federal system and the state system with respect to criminal prosecutions?
Yeah, so in essence, and it's a good question, a very common question that students have. In essence, we have the same role in the sense that both assistant district attorneys and assistant United States attorneys prosecute crimes. The biggest difference is that assistant district attorneys or state prosecutors' offices are handling every single arrest that is brought in by the local police department. We'll often refer to those as reactive arrests. So an individual shoplifts from the mall, is running from the store, gets arrested, the police arrest him. Those types of cases where there's an arrest and an immediate presentment of the case, by and large, are the types of cases that go to the local district attorney's office. Often we will work hand in hand with them, and sometimes some of those cases will be brought into federal prosecutions. But what's more common in the federal system is that the types of cases that Agent Shaliro was talking about, we're working with those federal agencies to build the case from the ground up and have long-term investigations as opposed to reactive cases where we're reacting to the arrest and doing the prosecution. We're really involved integrally in the prosecution and maybe doing things like, for example, here on Long Island, we'll be looking at what crimes are actually affecting the Long Island community and then work in tandem with our partners in the federal agencies to decide what types of cases really we should be focusing on and where federal resources are warranted.
Right. Now, Ms. Beckman, Mr. Shaliro and you discussed about the role and the cooperation between the Federal Bureau of Investigation and the U.S. Attorney's Office. But I'm just curious, does the U.S. Attorney's Office also work with other investigative agencies?
Yes, there's a host of federal agencies that we work with. FBI is obviously one of those primary agencies. We also work with the Drug Enforcement Administration, the Bureau of Alcohol, Tobacco, and Firearms, Homeland Security, the Postal Inspection Service, the Secret Service, the IRS, and we also work with local law enforcement. Often members of the local police departments will become members of federal task forces to work in some of those areas I've spoken about that are plaguing a particular community.
So let me just ask you a question that's a little bit aside from the investigative process. I know also when students come to see us, we tend to receive a number of questions about the grand jury process. So I thought it might be interesting to have you just explain briefly what the grand jury process involves.
So the grand jury is really an investigative tool as well as a vehicle by which we return indictments or charging instruments in a particular case. So if the FBI, for example, brings us a case and they have an investigation and they want to obtain something like bank records, or if it's a violent crime case, they want to obtain medical records, those subpoenas will be issued on behalf of the grand jury. The grand jury is actually a physical group of people. It has to be 23 people in total. We must have 16 present for a quorum. And at the fruition of the end of the investigation, or when the investigation comes to fruition, what we will do is actually present the evidence that's either been obtained by subpoena, or if, for example, we want a particular witness to come in, we will subpoena that witness, bring them in front of the grand jury, and they will be questioned by an assistant United States attorney in front of the grand jury. There is a court reporter or a recording device in the room, but the only people present or allowed to be present in the grand jury are the prosecuting attorney and the witness along with the grand jurors. It's completely secret. The witness is permitted to tell other people if they've been in the room, but the grand jurors are sworn to secrecy, and the prosecutors, as well as any case agents working on that, under the federal rules of criminal procedure, are all sworn to secrecy about what's going on in the course of that investigation. When it comes to an end and we've presented all the evidence, we will ask the grand jury to vote an indictment on a particular case. And ultimately, that's the charging instrument that a defendant is brought to court on. And ultimately, if there's a trial, that will be the instrument they go to trial.
So when a suspect is arrested or taken into custody, or you now have an indictment from the grand jury, what is typically the next step that you take in the process?
So after a suspect is brought into custody, and you'll hear from some of our other panelists, they are brought to pretrial services, and I'll let Ms. Mackey speak about that. But ultimately, as far as where the United States Attorney's Office gets involved next, that would be at the arraignment and detention hearing. And what will happen is after a suspect is brought into custody, they need to be brought before a federal magistrate within 24 hours of their arrest so that they can be arraigned. That is where they'll be notified of what the charges are against them. If they can't afford an attorney, they'll be appointed an attorney, and they'll be allowed to enter a plea of not guilty or guilty at that time. Usually in tandem with that proceeding is when the government will ask for bail or detention during the pendency of the case. And we will present our reasons why we feel that an individual should either be detained or, if released, they should be released on a particular bond where a certain amount of money or collateral is required to be put up in order for them to be released pending the outcome of the case, the trial, and or guilty plea.
Well, thank you so much, Ms. Beckman. I think it's probably a good time for me to turn my questions to Ms. Mackey in the role of the Pretrial Services Office. Ms. Mackey, why don't I just begin? Ms. Beckman just mentioned the role of pretrial once a suspect is arrested or taken into custody. Can you please explain to our students exactly what you folks do in pretrial services?
Sure. A U.S. Pretrial Services Officer is basically a bail officer. When an individual is arrested and brought to the federal court, they come to our office first. We do what's called a bail investigation. We ask them background information about themselves, and then we prepare a report for the court, making an outline as to whether we feel the defendant is suitable for release or if the person should be held pending trial.
Mm-hmm. And what kind of information does your office typically gather in order to prepare that report?
We usually ask basic background information, their date of birth, social security number, where they live, who their family is, if they have any ties, family, friends in the community, how long they've been in the community, if they're employed, where they've been working, we ask about their financial status, if they have any assets, homes, cars, bank accounts. We also ask about their health, whether they have any health issues the court needs to be aware of, including mental health issues or drug issues they may have. And we gather that information, and we also ask that they provide us with someone, either a family member or a friend, that we can contact to verify that what they're telling us is correct. Once we gather that information, we also conduct criminal record checks and financial checks to confirm, to see if the person has any prior criminal history, if there's any warrants or out for them in other districts. Once all that information is gathered, we prepare a report for the court, and in that we list the defendant's risks of either flight or dangerousness to the community, and make a recommendation as to whether they should be released or detained pending trial in this case.
So in addition to preparing the report for that determination, with respect to suspects that are then released, does the Pretrial Service Office have any role with respect to those defendants?
Yes. Yeah. Basically, the court will issue some guidelines for them while they're out on bail, and will set certain conditions. Some of the conditions could be that they report to my office weekly, monthly. They may have to submit to random drug testing and treatment if we felt that it was required. Also, if they're in need of mental health treatment, we would refer them for mental health counseling. Some individuals may be at a higher risk, so we may require them to be placed on home detention with location monitoring. So that's basically a bracelet so that we can monitor their whereabouts, so we know where they are during the day and make sure that they're not committing further crimes while they're out on bail.
So, Ms. Mackey, let me ask you a question. I want to certainly go on to discuss a little bit more about when the defendants are first brought into custody. But before we get too far, I do know that the Pretrial Services Office also has a role in the end with respect to sentencing. Can you just describe a little bit that role?
Basically, at the end, at sentencing, the court always seems to like to see how the person has been doing under our supervision. So we prepare a memo for the court or a status report stating whether they've been compliant, if they've remained arrest-free, if they've stayed drug-free, if they've been attending their mental health counseling as required. So the judge can make a determination whether this person would be suitable for either probation, or if they haven't been compliant, whether the person should be remanded immediately after sentencing.
Well, thank you so much, Ms. Mackey, for that information. What I want to do is turn my attention to now Ms. Chavis. Ms. Chavis, Ms. Beckman mentioned when we were discussing the U.S. Attorney's role that when folks are first brought into custody, they have a right to counsel and they're advised of their right to counsel. Can you just begin by describing the role of the federal defender in the criminal justice system with respect to that right?
Federal defenders are appointed to represent people who are arrested, who have found to, who are determined by a judge to be indigent or too poor to hire a private attorney. And so federal defenders is assigned to a case when the person comes into the building. As far as the right to counsel, that of course attaches when a person is first taken into custody. And that is often, that could be hours, if not a day, before they are brought into the courthouse, depending on what time of day they were arrested. And there's often plenty of opportunities for the agents who arrest them to question them if the person is willing to talk to the agent, which they should never be. Just saying to anyone listening, you have the right to remain silent and you should use it until you have an attorney assigned to talk to you. But that's our role. We are assigned to represent the person from the very beginning of the case, starting with the bail, starting with the arraignment on the charges and the bail application, all the way through the arraignment on the indictment, any suppression motions that might be filed, any sort of any other legal issues that might arise that we could use to fight the case against the person, and then all the way through to sentencing if we're not successful in getting the case either a not guilty verdict or a dismissal or some other sort of outcome that doesn't involve a sentencing.
So let me just clear something up. When a defendant is brought into custody, and assuming they'll be assigned to the federal defender's office, how soon after they're brought into custody do you typically get to meet with the defendant?
So just to, once again, so brought into custody, mostly in this context, we've been talking about being brought into the courthouse. Right. Whereas really custody begins when a person is not free to leave if they've been arrested or taken in for questioning. We very rarely are involved prior to a person being actually brought to the courthouse. But once a person is in the courthouse, we are assigned immediately, really. And and in fact, we usually sit in on the interview that Ms. Mackey described, where the pretrial services officer asks the client at that point about the background information that they're going to use to put into the report that they prepare for the judge. But even before that happens, where we sit in with them on the pretrial services interview, we've met with the client in the marshal's pens, where we do an intake interview with the client and try to get as much information as we can. A lot of it is similar to what the pretrial services officer is going to ask, but we're seeking that information so that we can put together a bail package, as it's called, but basically a proposal for the judge that we hope will be sufficient for the judge to decide to release the person so that they can be free during the time that their case is pending, so that they can come to the office a little bit easier, so that they can help in their defense. Those are some of the things that we're looking for in the information for bail purposes when we're talking to our client. It's also an opportunity to establish some rapport with our clients so that we can hopefully give them the confidence that we are their advocates, no different than if their family or they could afford to hire somebody. All the same rules apply to us as far as confidentiality and our obligations to our clients. So those are all things that we're trying to get across in that initial interview, which does take place well before we see the judge.
So, it's probably somewhat repetitive of the questions I've asked about the type of cases that are typically investigated or handled by the U.S. Attorney's Office, but let me just go over again with you. Just personally, what type of cases have you or what type of crimes have you been asked to handle?
It really runs the full gamut. We have we represent people in homicide cases. We also represent people who are accused of committing bank robberies, selling drugs, using somebody's credit card information to defraud a merchant, or if they steal a person's identity is a federal crime that we've done. Of course, many drug cases, all different kinds nowadays, more fentanyl cases and more heroin cases, but for quite some time, a few years ago, many years ago, really at this point, crack cocaine cases. And in addition, we've had, not recently, but we have Secret Service cases. If the president is threatened and they arrest somebody for that, we might represent somebody on that. All the Medicaid fraud, what we've represented people. It's really just, as Ms. Bachman said, and the FBI agent, there's almost no kind of case that we don't handle. Except for the crimes that rich people commit, because we don't have any rich clients.
Right. So let me ask you a question, and it's something that, as you know, you and the programs that we do live are almost always asked by some of our students. So I'm going to ask you: is it hard to represent defendants?
It's not hard. The people in my office, the lawyers in my office in particular, really believe that what we are doing is a very worthwhile, very important job. And it is not only to protect the rights of the people who have been arrested and who are our clients, to make sure that they are treated fairly, but it's also a big part of what we do is to make sure that that the rules have been followed, that the constitutional rights that everybody has, the Fourth Amendment right to be free from an unreasonable search or seizure, the Fifth Amendment right to not incriminate yourself or to testify on your own behalf if you want to, and the Sixth Amendment right to a fair trial and a speedy trial. Even if you've never been arrested, those are very important rights that everybody has. And if there's not somebody out there making sure that those rights don't get eroded or compromised in some way, then we're all suffering. So it's not hard for me and the other attorneys in my office at all to represent people who have been accused of committing crimes, because they deserve a fair, aggressive, vigorous defense, and the system needs people keeping an eye out to make sure that it doesn't completely fail citizens of our country.
Well, thank you so much, Ms. Chavis, for that. Given our time limitations, let me just jump over to also a big part of our criminal justice system, and assume for the last part of these questions that perhaps the trial has already taken place, because I do want to spend a little bit of time talking about the role of the probation officer. So, Ms. Langone, again, thank you for joining us as well. Can you describe for our students the role of the U.S. Probation Office within the context of the criminal justice system?
Sure. The probation department operates in some aspects very similar to pretrial services. The probation department usually enters a case toward the end after an individual has either been found guilty of a crime or pled guilty. Within the probation department, we have two separate divisions. One division is the pre-sentence division. And the pre-sentence division, again, very similar to pretrial services. They receive information about a defendant who has either pled guilty or has been found guilty during a trial. And they will prepare, the officer will prepare a very extensive pre-sentence report for the court. And it provides very detailed information basically about the individual's entire history, personal history, criminal history, which includes, the gamut of education, where they were born, their relatives, all that information, as well as information about the crime itself.
Mhm.
And that report is heavily relied upon by the court in making a determination for the sentence. Once individuals are sentenced, they're sentenced to, either a term of custody with supervision once they're released, or they're sentenced to a probation term. So we then have our supervision division, which assumes supervision of these individuals when they receive that sentence. So if an individual is serving a custody term, when they are released, generally they have a term of supervised release. It could be 2 years, 3 years, 5 years. Our supervision division will assume supervision of them. And usually there's special conditions that need to be followed by the individual during that time period. So the officer will be responsible for ensuring that these conditions are met, such as substance abuse treatment, mental health treatment, home confinement, location monitoring. And the same goes for individuals who are sentenced to probation.
Mhm.
There's no distinction between supervised release and a probation term, other than what it's called. Probation, you don't serve any custody time, and supervised release, you did do some custody time, even if it was as little as a day.
Right. So let me ask you, with all of those roles, like, what does your typical day look like?
Well, a typical day for an officer is definitely busy. There's a lot of interaction. The caseloads, they could have 40, 50, sometimes 60 individuals under their supervision. So either you're doing some office-based work, every case, we need to keep detailed records of our interactions with the individual, how they're progressing. Unfortunately, some of these individuals do not abide by the terms of their supervision, and it requires reports being sent to the court, violation reports, requests to modify these conditions. Maybe we want to add some additional conditions because they're not doing so well. And a lot of the work also involves going out and visiting these individuals at their homes, at their place of employment. It's twofold. It's to verify that they're doing what they're supposed to be doing and they're where they're supposed to be. But, we're also a presence for them in the community. Some of these individuals have had, a long history of criminal behavior, and they don't really have the skills to be more successful in a positive way. So part of the officer's job is, yes, to enforce the conditions and ensure that, they're doing what they're supposed to be doing, but we're also there to provide them with resources that they may need. So going to their residences and having conversations, not just with them, but with the individuals that they reside with, you'll get some information about how they're doing, what they may need. And it's a source sometimes, when used appropriately, it's a good source for them. It's a good resource for them to utilize. And it creates an odd relationship, because it is not exactly a friendship, but when you're spending 2, 3, 4, sometimes 5 years with an individual, you get to know them very well.
Sure. And
So
over that
it's an
period of
interesting
time,
position.
yeah, and so over that period of time, the individuals that you do supervise, how often do you typically meet with them?
It depends, generally on a higher risk case, we'll definitely see those individuals at least once a month, sometimes
Mhm.
more than that. There could be circumstances in a case that they need to be seen once a week. Some people require a lot more attention than others.
Right.
So it really depends on the risk level, but at a bare minimum, they're being seen on a monthly basis.
Ms. Lenko, let me just end by asking you the same question that I asked Mr. Schleier at the beginning, because I know our students are so often interested in how one becomes a probation officer. Can you just talk about perhaps your path, how one becomes a probation officer and what training is involved?
So an applicant will go through some initial screening exams in our office. Once they go through that screening and some panel interviews and they are offered the position, they have to go through a background investigation, a medical exam, and a few other procedures. And when they're given a final offer, then they go through approximately 2 months of training. There's a couple of weeks of in-house training to begin, and then there's about 6 weeks of training at FLEXI, which is the Federal Law Enforcement Training Center in South Carolina.
Great. Well, thank you again for answering those questions. And, I'm looking at our time, and I think we're running out of time for today's session. So let me end by sending out a very heartfelt thanks to all of our panelists for joining us today. We hope that the students join us tomorrow for part 3 of Bench in Your Backyard, the constitutional amendments. Tomorrow's panelists will consist of Magistrate Judges Scanlon, Tomlinson, and Locke, who will be reviewing some of the key amendments and talking about the ratification process. Thank you again to all of you for joining us, and have a great day.